Welcome, my fellow tax professionals. Today we're going to be discussing the key issue of whether the offer and compromise application packet is processable. We're also going to be discussing some malpractice traps that result in the application being deemed unprocessable by the IRS. I hope you enjoy the video. Think of the IRS as an investigator. The IRS starts the offer and compromise application process with a simple question. Is the application processable? As a reminder, an offer and compromise must be made in writing, and an oral offer is not permitted. Processable applications are deemed pending and continue on with the IRS's review of income, expenses, and assets to help calculate the IRS's reasonable collection potential. Unprocessable applications are returned and the application file closed without the taxpayer receiving relief from back taxes. So the obvious question is, what causes an offer and compromise application to be deemed unprocessable by the IRS? A doubt as to collectability offer will not be considered if the taxpayer has the ability to pay the tax liability prior to the collection statute expiration date. An offer will not be considered if the taxpayer has failed to file any tax returns that the taxpayer was legally required to file. Plus, estimated income tax payments may be required for W-2 employees, 1099 employees, and self-employed taxpayers. The self-employed taxpayer must be current with filing and payment requirements for the tax year in which the offer was submitted in order to be considered for an offer and compromise. A taxpayer with employees must be current with filing and paying all federal tax deposits in order to be considered for an offer and compromise. The taxpayer with employees must make all required federal tax deposits for the current quarter. An offer also will not be considered while a taxpayer is in bankruptcy. Let's continue to explore additional reasons the IRS deems an offer and compromise application unprocessable. An offer will not be considered if the tax liability a taxpayer seeks to compromise has been previously referred to the U.S. Department of Justice for prosecution or defense. An offer will not be considered if the taxpayer is in an open audit or has received notice that a tax year will be audited. An offer will not be considered if the taxpayer is seeking to compromise tax liability that has already been litigated and reduced to judgment by a court. An offer will not be considered if the taxpayer submitted the offer in bad faith and solely to delay collection. An offer also will not be considered if the taxpayer is associated with tax avoidance scams or transactions, fraud, tax protesting, criminal tax behavior, and refund schemes. Thank you for listening to this video, and please spread the word to your fellow tax professionals. The National Offer and Compromise Academy is available to help professionals expand their practice into the profitable area of offer and compromise. The music for this video was provided by www.bensound.com. You can contact the Academy from its contact page at www.oicacademy.com. Enjoy the online course and keep on learning.